Company means company registered under Companies Act 2013 or any other previous law. Companies Act is applicable to all companies including banking, insurance, electricity. Okay, so far as they are not inconsistent with the Companies Act. If there is an inconsistency, which prevails? Special Act prevails. If the Special Act is silent, Companies Act prevails. What are the features of company? Separate legal entity, perpetual succession, limited liability, artificial judicial person. Now, what is separate legal entity? Company is different, owners are different, okay, members are different. Perpetual succession? Okay, so even members change happens, that did not wind up a company. What is the liability of members? Limited to the extent of shares or guarantee. What is artificial jurisdiction person? It's legally created by law. So it is not natural person, it is artificial person. What are the case laws we studied for separate legal entity? Solomon versus Solomon. Lee versus Lee Air Forming Company. These two case law we studied. Whether common seal is mandatory?
No, sir.
No, common seal is optional now. What does corporate will means? Separate legal entity. When generally you lift the corporate will? Okay, generally we will lift the corporate will only when there is a fraud. Example, what is the case law we studied? Gallagher versus Germania Breweries. Then, when tax evasion has happened in the name of the company, Dinshaw, Menakji, Petit, tax evasion case. Okay, then Guilford Motor Company versus Horney, breach of contract in the name of company. Then trading with enemy country, என்ன case law? Daimler versus Continental Rubber Tire. Okay. What happened in this case laws? Dinshaw Menakji Petit, what happened? One person opened so many companies. He transferred his income to so many companies and none of the companies paid tax, and he took loan from those companies. He also didn't pay tax. Correct, Alia? We studied this or not? Next. Daimler versus Continental Rubber Tire, what we studied? Do you remember this or not? Daimler versus Continental Rubber Tire. Daimler is a German company. Continental Rubber is a UK company. This company borrowed, means this company was buying tires and etc. So suddenly one day war broke out. Even though this Daimler company is registered in UK, much of the members are what? German members. During war time they will see them differently. Okay, so generally company and members are different person, but at times we will make them equal. So both are same, we will be studying. Then Associated Rubber Tire, where which case law it is? Employee legislation violation. Okay, workers, okay, they split the number of companies so that none of the companies will have how many members, how many employees? 20. I told you labor welfare law, 20 employees if they come, bonus, PF law, it will become applicable. Okay. So instead of making them applicable, what they used to do? They will split the number of companies so that none of the companies will have 20 employees. Understood? You should not use the company as your agent. Okay, if people started doing the business kind of, company will be treated as my agent. whatever I want to do, I just do it through the name of company and do some fraudulent activities. So they will lift the corporate veil. So under broad headings, when and all they will lift the corporate veil. Trading with enemy country, revenue tax violation, okay, whatever you have to do you are not doing, okay, splitting the name companies, legal obligation, then okay, subsidiaries to act as agents, fraud. Okay, next, what are the types of companies? Incorporated the company, okay, there is nothing called unincorporated company, only after incorporation they will be called as company. Company limited by liability, limited liability, unlimited liability. Limited liability company limited by two. One is shares, another one is guarantee. Okay, with share capital, without share capital. Okay, guarantee with share capital, guarantee without share capital. Okay. Then we have unlimited company also. Unlimited company also with share capital, without share capital. Then we have private company, public company. Okay. Then we have listed company, holding company, subsidiary company, associate company. 1% company, small company, dormant company, Nidhi company, government company, foreign company. Okay, these many classifications we have. Section 8 company, very good. Company limited by shares. Okay, what is the features of that? The liability of a member is unpaid amount of share capital. Once the shares are fully paid up, there is no more liability. Company limited by guarantee. At the starting of the company, when they want to start a company, they won't pay any amount. Okay, even during the going concern, they will not ask any amount. When they will ask you to pay the amount? At the time of winding up. That too, what amount? The amount you have guaranteed that you will pay. What is unlimited company? The liability of members is unlimited. So in case the company's assets are not enough to pay their liability at the time of winding up, then members have to pay that amount. So creditors in this company will not lose anything. But in limited liability company, creditors will lose something if the company's assets are not sufficient to pay off the liabilities. What is 1% company? 1% company is a dash company. It's also a private limited company, but they have only one member. Okay. Who can start this company? Only natural person can start this company. That person should be a resident. Okay. They should have nominees, right? That nominee should also resident in India, and he should not be nominee in some other 1% company. 1% can start how many 1% company? Only one 1% company. Okay. How many directors should be there? Minimum 1, maximum 15. How many members should be there? Only 1. What is the maximum turnover of this company? 2 crores. What is the maximum paid up capital? 50 lakhs. Very good, very good. So you guys have really studied. At least if you have studied my notes, you can able to answer all my questions. Even if you have not studied the full book, if you can able to study my notes, that's enough. I don't want to give any advice now because we are running short of time. We'll just do revision. Can a minor become a nominee of OPC? No. Can we change the nominee at any time? Yes, we can change the nominees. Whether the nominee name should be mentioned in the memorandum itself? Yes, generally memorandum has 6 clauses, but OPC alone they have 7 clauses. Whether OPC has separate legal entity? Yes, OPC also have separate legal entity. Okay, now we will go to private limited company. What is the restriction a private limited company has compared to public limited company? What are the restrictions? Transfer of shares, maximum number of members restricted to 200. Okay. Then you cannot invite public for deposit of shares. Okay. Then you cannot invite public for subscription of deposits. You cannot issue prospectus. Okay. Then in maximum number of 200 members who are not considered. Okay, employees who become shareholder while they are in employment and continue to be shareholder even after employment ceased. Come on, tell me. Employees who became shareholder during their employment and continue to be a shareholder even after their employment ceased. Next, is there any minimum paid up capital requirement for companies? There is no minimum paid up capital requirement. What is minimum shareholder requirement for private limited company? 2. What is the maximum shareholders? For public limited company, what is the minimum shareholders? What is the maximum shareholders? Very good. When a company is called a small company means dash company, private company, which is satisfying 2 conditions. Paid up capital less than or equal to 50 lakhs, turnover less than or equal to 2 crores. Additionally, 3 conditions. It should not be a Section 8 company. It should not be a holding company or subsidiary company. It should not be a but a pavi company itself is a body corporate, right? It should not be a body corporate and it should not be incorporated under special act. Very good. Come on, tell me what. Hey, de thambi sollu. Enna irukku body corporate? Enda heart breaking da. Okay, it should not be a special act company. The company itself is body corporate, ra. It should not be body corporate enna artham. Body corporate is a broader definition. Can you please understand what is body corporate? Body corporate is a broader definition. Company is a smaller definition. All companies are body corporate, but all body corporates are not companies. Okay, because LLP is a body corporate. ICA is a body corporate. What is body corporate? ICA is a body corporate. See, that's called body corporate. It's an organization. It's a corporate. Okay, RBI. It is registered under a special act of parliament. It is having separate legal entity. Okay, it will be managed by elected members. The owners will not be the managers. It will be managed by elected members. These features are there in body corporate or there in company also. But company means company registered under Companies Act. Body corporate means special act of parliament. Any special act of parliament. For example, SBI. SBI is a SPA Act. All banks generally will be registered under Banking Regulation Act as well as Companies Act. Please understand. Bank will be registered under Companies Act as well as Banking Regulation Act. But SBI is there, no. SBI will not be registered under Companies Act. Why? SBI has its own act. LIC. LIC Act separate. RBI. RBI Act separate. ICA Act 1949. So, the entity they have a separate act in the parliament. They will not be registered under companies. So, those things are called as what? Body corporate. Purunjida? So, what is body corporate? Body corporate is an entity which is registered under a separate act. Okay, it will have a separate legal entity, purpose of succession, all the features of the company also it will have, but it is not registered under Companies Act. Purunjida? So, special acts is single word, special acts. So, come on, tell me, small company should not be a holding or subsidiary company, Section 8 company, or special act. Okay, special act companies. So, generally special act companies they will call as body corporates. Public company. Public company. Come on, tell me. Public company is not a. Public company can invite public for subscription of shares, deposits. Maximum number of members. Maximum number of members. Unlimited. Minimum members. Very good. What is a holding company? Holding company means a company which controls another company. Which company which controls? Company. They will have shareholding, or they can control directors, voting powers. Okay. So a company which has voting power, which can exercise more than 50% voting power on another company, then they are called what? Holding company. The company which is getting controlled. Okay. What is associate company? Associate company means a company in which another company holds significant influence. What is that? 20% of total share capital. That means equity capital plus convertible preference. Nada, forgot. Come on, associate company. 20%. Subsidiary company na? More than 50%. Associate company na? 20%. So, till when a company is called as associate? Till 50%. If it crosses 50, it's subsidiary. Okay. What you will call as subsidiary of a subsidiary? That also subsidiary. So A company has B company, B company has C company. C is also subsidiary of A. Next. Listed company. Company which is listed in the stock exchange. What are the two famous stock exchanges in India? What is an unlimited company? Unlisted company, sorry, unlisted company. Any company other than listed companies. What is unlisted public company? Public company which is not listed in the stock exchange. Generally, when they will go for listing? When they ask capital from public. When they ask capital from public, they will go for public issue. Then only they can go for listing. What is government company? Not less than 51% of the paid up capital is held by central government, state government, or one or more state governments. Okay. And subsidiary of a government company. So subsidiary of a government company is dash government company. Can we form a company with charitable object? Can we form a company with charity object? Can we form a partnership firm with charity object? Only for business. Okay, for profit. Okay, partnership firm. You completed partnership firm test. We will be doing it after Companies Act. Next. So we can incorporate a company to promote charity object. Okay. Who has to give permission for that? Central government. So incorporation of charity company needs what? Central government's permission. Charity company, whether should they have a name called private or public limited ending? Okay. They can have the words like club, federation, chambers, etc. Can central government revoke the license? Yes. Okay. If they are not doing charity object. What are the objects possible under Section 8 companies? To promote trade, commerce, religion, charity, education, okay, sustainable development, research. Can they declare dividends? Section 8 company, can they declare dividends? They should not earn profits itself. They should not? Okay, so if at all they earn profit, they should again use it for the company's charity object. Okay. If central government revokes the license, what they will generally do? Ask them to amalgamate with another company which is having this object. Okay. Is there a minimum requirement of paid up capital? No. Generally, how many days notice should be given? 21 days notice. But for section and company alone, 14 days notice. See, whenever you want to call a general meeting of members, you should tell some days in advance. For example, if I tell you tomorrow test, will you write? You tell, sir, at least 2 days in advance you should tell. So what I will tell? Monday Companies Act test. Okay, so you will accept it and you will write it because I have given enough time for you. Can you able to understand? So that means Monday Companies Act test. And that's why we are doing revision now. Okay. Next, how to incorporate a company? How to incorporate a company? To form a company, to form a Section 8 company I am talking about, what you need? You need central government permission. Next, should the company use the word limited or private limited in the end? Okay. Tell me, what is dormant company? Huh? Dormant company will not do any significant activities. What does not include in the word significant activities? They can do 4 activities. Dormant company, still they will be called as insignificant activity company. 4 activities they can do. What are the 4 activities they can do? They can maintain office maintenance expenses, record maintenance expenses, ROC fees, taxes, dues. For that money they can allot shares. What is Nidhi company? Sorry, dormant company generally why they create? To hold intellectual properties. Okay, some formulas or intellectual property they can generally hold, that's all. They won't do any activities other than this. Then Nidhi company, for what purpose they incorporated this company, Nidhi company? To collect deposits, okay, savings attitude, to develop a savings attitude between the members. So who will be the members? Only individuals. Okay, minimum 200 members will be generally. So they will collect deposit from the members, they will give loan to the members. But it's not chit company. Chit company is based on bidding. Nidhi company is based on merits of a person. Okay. What is public finance institution? How many public finance institutions are there in India as of now? Life insurance. LIC. LIC. IDFC. UTI. Future la central government if they thinks they can introduce few more companies. Okay. So come and tell me how many public finance institutions are there in India? LIC, UTI, IDFC. What is IDFC? Infrastructure Development Finance Corporation. Okay. Don't tell industry. It's infrastructure. Okay. In public finance institution, 51% shares will be generally held by governments. You can incorporate a company, either public company or a private company or 1% company. Okay. Now, what are documents to be filed? First of all, you should give a declaration that the promoters are not disqualified. Okay. None of the promoters are, that is subscribers of the memorandums are disqualified. Then you should have directors of the company. First directors. In case of private limited company, 2 directors you need 3 directors in the case of public limited company. Subscribers you need 2 in the private company and 7 in the public company. And you need address of correspondence. But this is not called as register office address. Address of correspondence is temporary address. After incorporation also we can change your address and you can tell that is a register office address. Then once you decided to form a company, you have to tell what are the objectives of your company. So you should find objects that will be seen in which document of the company? Memorandum. Okay. Why it is necessary to register the memorandum? Because everyone who is dealing with the company should know what the company can do. Because if the company is doing something else, that's called dash, ultra vires, and the company can escape saying doctrine of constructive notice. You should have read அப்படின்னு சொல்லுவோம் company. Okay, you should have read. So what is the document which saves the doctrine which saves the third party from the company? Doctrine of indoor management. We assume that you have followed this. Okay. If you suppress the information and give false information, okay, can ROC challenge the certificate of incorporation? Okay, if you give false information, they will challenge it. But if you have some errors in incorporating, they will not, okay, cancel the certificate. So once you incorporate a company, you will be getting a number that's called corporate identification number. In case if you gave false statements, false declaration and got your company incorporated, which authority will deal your cases? National Company Law Tribunal, NCLT, National Company Law Tribunal. What they will do? They will tell the liability of members is now unlimited, as if there is no company. And they can struck off the name of the company from the register of companies. Now, which form we are using to incorporate a company in a single form? Which form? SPICE, SPICE, simplified pro forma for incorporating company electronically. Pro forma means format. Now, classification of the capital. What are the types of capital? Authorized capital, or also called as nominal capital or registered capital. Issued capital, issued for subscription. Then subscribed capital. Then called up capital. Then paid up capital. What does mean by share? Share means share in the share capital of the company. Share means share in the share capital of the company. What are the kinds of share capital? Equity capital, preference capital. What are the two types of equity capital? With voting rights, with differential rights. Very good. What is differential rights? Differential rights to dividend, voting. That means you can get more dividend, less voting. Can you able to understand? What is the maximum percentage I told you? Differential voting rights. What is the maximum percentage of differential voting? Don't see the book, it will not be there in the book. I told you in class. Maximum 26%. A company can have only maximum 26% differential voting rights. 26. Memorandum. How many types of memorandums are there? Table A, B, C, D, E. Okay. This is in which schedule of the Companies Act? Companies Act has 7 schedules. Memorandum and articles has, okay, schedule 1. Schedule 2 is rates of depreciation. Schedule 3 is financial statements format. Okay, schedule 5 is remuneration of directors. These are very important schedules for us. Schedule 4 and schedule 6 is not that important to us. So when your accounts you are putting depreciation, no, that is depends on which schedule of Companies Act. Schedule 2 of the Companies Act. You are putting final accounts, right? Balance sheet. Under which schedule the format is given? Schedule 3. Okay. Contents of memorandum. Come on, tell me. First clause, name clause. Second clause, situation clause. In situation clause, you should have only the state in which the register office is situated. Nandanam எழுதுவியா ராயப்பட்டான் எழுதுவியா what is exact address you should not write you should write only state. Next object clause. Third clause is object clause. Fourth clause liability clause. Fifth clause capital clause. Sixth clause subscription clause. What is doctrine of ultra vires? Beyond the scope of memorandum. So any activity beyond the memorandum is ultra vires, which cannot be ratified. Beyond articles can be ratified, but beyond memorandum cannot be ratified. What is the case law for ultra vires? Hashbury Railway Company versus Ritchie. What happened in that case law? The company shouldn't have done finance business because it is not there in their object. They are basically engineering company, but without changing their object they started doing a finance business. Can they change the object? Yes, by passing special resolution they could have amended the object clause. Correct இல்லையா? How to amend the object clause of a company? Pass special resolution.
But it was general contract
financing not allowed. Contracts is allowed. It's basically engineering company. See, first of all, whenever you are transacting with a company, you shouldn't have transacted with the company. Whenever the company is transacted, they shouldn't have done the transaction. So it's a problem with both these people. That is the reason no one can sue anyone. Okay, ultra vires and doctrine of contingent industries is like no twin brothers. Okay, நீ பண்ணதும் தப்பு. Okay, next. Articles of association. What is articles? Internal rules and regulations of the company. What to do is mentioned in MOA. How to do is mentioned in articles. Okay. Can they have amendments in articles after incorporation? By passing special resolution, they can amend the articles. சும்மா எல்லாத்துக்கும் எஸ் நோ சொல்லிகிட்டே இருக்கக்கூடாது. என்னதுக்காக சொல்கிறோன்னு தெரிஞ்சுக்கணும். கதரை எடுத்திருக்கேன் 6 hours கம்பெனிஸ் ஆக்ட். அதுக்கப்புறம் ரிவிஷன் பண்ணுறோம். Now see, both MOA as well as AOA clauses can be changed. For example, can you change name clause in MOA? Yes. If it is compulsory, central government or someone is pressurizing you, you can change the name clause in MOA. If it is voluntary, then you have to pass special resolution. If it is compulsory, then you should pass ordinary resolution. Can you change the situation clause? Can you change from your company from Royapeta to Nandanam? Yes, within city. எல்லாத்துக்கும் I can change except 2 clauses. In memorandum, 2 clauses I cannot change. Subscription clause and liability clause I cannot change. Whoever formed the company, they only formed the company. Even they die, even they transfer the share, that cannot be eliminated. Can you able to understand? See, whoever has opened a bridge, one flyover is there. One chief minister opened the flyover. He died after a few years. Can you change the event? This person only opened the flyover. You cannot change it, right? Same thing. So subscription clause is like that. Who opened this company? Who was the promoter for this company? That cannot be changed. Liability clause, you cannot change it. But capital clause, you can change it. You can increase the capital. Okay, authorized capital today is 1 lakh. Tomorrow it can go up to 10 lakhs. Day after tomorrow it will go up to 1 crore. That can be changed. Understood? Whenever you are altering the articles, keep in mind 2 things. You cannot alter the object beyond the memorandum. You cannot alter the articles beyond the act. So always articles, when you are changing, you should keep in mind what? 2 things. One is memorandum, another one is act.
So Article of association is also called as
Articles of association is also called as internal regulations of the company. Magna Carta. Memorandum is called charter, article is called Magna Carta. Internal regulations. Third parties can assume that the company have followed their internal rules and regulations. This is called doctrine of indoor management. What is doctrine of indoor management and how it is different from doctrine of constructive notice? In doctrine of constructive notice, it is negligent on the third parties. They are not knowing anything about the company and they are transacting with the company. For example, if a student joins a college, he should ask about this college to so many people, how it is, etc., etc. Then only you should join the college, correct? And you cannot complain afterwards. You have to abide by the rules and regulations of the company. And the company also, before transacting with you, they should check whether they are eligible to do this activity with you, whether at all they are eligible for doing this activity. So both the people are having duty to do this. Understood? So if you are doing something not as there in your kitty, okay, memorandum, object clause, if anything you have done, it is null and void. You cannot sue anyone, no one can sue you. Okay, next. Doctrine of indoor management protects the third parties. Okay, internal. Okay, I assume that you have followed all these rules and regulations. How do I know that you have not followed the rules, which is between you people? So I can assume that you have followed rules and regulations. So I am protected. But doctrine of indoor management can be claimed by third party. But even though we are saying directors are also third party, separate legal entity concept, directors cannot claim doctrine of indoor management because they are the inside people who should know all these rules and regulations. Can you able to understand? Okay. And in fraud case, so what is exception to doctrine of indoor management? Gross negligence case, fraud case, directors case. What is the famous case laws for indoor management? Royal British Bank versus Turquoise. In Royal British Bank versus Turquoise, what happened? A company got loan. Okay, 3 directors should have signed, but only 2 directors signed. Okay, and when they are repaying, the one director is not allowing the company to repay, and he is saying what? 3 directors should have signed, only 2 directors signed. But what third party argued? These regulations and all not known to us. It is not mentioned in the memorandum itself. Okay, we are obliged to do reading of memorandum. We have read that, and we assume all your internal regulations are complied with. Okay, so you have to repay the loans. Abdina, they argued. One day, one director gave the loan to company without following the rules and regulations of giving loans or taking loans from the company. Then another director told that we will not repay the loan taken from you. Then this director told what? I assumed I am a third party when I am giving loan. On that scenario, I am a third party, like what Solomon told. When I give a loan, I am a third party. Okay, I am also like a creditor. Then what creditor argued? No, you are a company. You are the shareholder. You cannot argue like that. So what Solomon told? As a shareholder, I am a different person. As a creditor, I am a different person. Okay, can you able to understand? So same logic they are arguing here. Who this director is arguing? The person who gave a loan. Mr. A gave a loan to the company, violating the internal rules. Okay, and Mr. B, when the company is repaying, is not signing the check, saying you should have not given the loan to this company without my approval, because 3 directors have to sign. Then what Mr. A is arguing? Which case law? Turquoise case law. I am a third party. Okay, I gave loan. I saw memorandum. In memorandum, you are allowed to borrow loans. I gave loans. Okay, now what is exception to the doctrine of indoor management? Director cannot claim doctrine of indoor management because Mr. A should have known that only after getting the signature of Mr. B you should have given the loan. Can you able to understand? So Mr. A cannot claim doctrine of indoor management because he is an inside party, he is not a third party. He should have known the rules and regulations before giving loans. Understood? Next. So what are the exceptions we studied? Actual constructive knowledge of irregularity. Mr. A has a knowledge of irregularity. He cannot claim doctrine of indoor management. Then suspicion of irregularity. See, you are grossly negligent. You know that you should have taken some steps, but you are grossly negligent. Then forgery. Okay, what is the classic case law? Kali, Great Fingal. Reuben versus Great Fingal. Okay, what happened in the case law? One person gave money to some employee of the company, and the employee took the money from the shareholder, forged the signature of the director, and gave share certificate to the third party. Third party assumed that he got the shareholding, and he was attending the general meeting where everyone sees as I am a third party. Okay, sir, who are you? I am a shareholder. How it's possible? It's impossible, sir. He showed the share certificate. They told, sir, this share certificate, anyone can buy it from Sitaraman company. Okay, if you give 10 rupees, they will give you one share certificate. And this someone who have signed it. There is nothing to do with this company. Please get out. Someone have forged you. They may be even employee of this company. You cannot claim to be a shareholder because it's a forged one. So forgery is an exception to the doctrine of indoor management. Doctrine of indoor management is an exception to doctrine of constructive notice. But these 3 points are exception to the doctrine of indoor management itself. What are the 3 points? Negligence, suspicion of forgery, constructive knowledge. Okay, with this we completed Companies Act revision. Just imagine, it didn't take us more than 40 minutes to revise this. Okay, I will tell you exactly 42 minutes it took us for revision. That's all I am telling you. Companies Act is this much only. Conceptually, Companies Act is over. Conceptually, but to the point you should write in your examination. Okay, that's when you get more marks. Should write to the point. Write side headings. Each side heading you write 2 to 3 marks, 2 to 3 lines. Then only they will give you marks. Please put side headings in bold letters. And when you are writing answers, you write in normal letters. So side heading bold letters, normal. And make sure you are writing only in black pen. Don't use 2-3 pens. Okay, people are started using blue pens for headings and black pen for writing. Make sure you are using only one pen and show the difference in the same pen. Understood?